CIPP-E 2026 IAPP certification. This is the part of the complete course. You can get the link in description. Hi there, and welcome. I am so glad you are here. Before we start, I want to share a secret, a simple way to learn faster. Don't just read the words, imagine you are in the situation. When I talk about a controller, imagine you are the boss of a company. When I say data subject, imagine it is you, or your mom, or your friend. Privacy laws are not just dry rules, they are about real people. If you connect the rules to real life, you will remember them. Also, take your time with the explanations. The answer is important, but the reason why is where the real learning happens. So, grab a cup of coffee, get comfortable, and let's get started. Section 1. European Data Protection Context. Let's start at the beginning. You cannot understand the GDPR unless you know where it came from. Europe has a long history of protecting privacy. It did not start in 2016 with the GDPR. It goes back much further. Think about the Council of Europe. This is not the same as the European Union. The Council of Europe is a bigger group, and its main job is human rights. They created the European Convention on Human Rights. In that convention, look at Article 8. It says everyone has a right to respect for their private and family life. This is the foundation. Then, we have the OECD guidelines. These are not laws, but they are like good advice. They gave us the basic ideas we still use today, like limiting what data you collect. A very big moment was Convention 108. This was the first real binding international rule about data protection. It happened way back in 1981. It allowed countries to share data because they all agreed to protect it. Later, the European Union grew. They needed stronger rules. They made the Data Protection Directive in 1995. But a directive is weird. But it lets them decide how to write the law. This meant Germany had different rules than France. It was messy for businesses. So, they made the GDPR. It is a regulation. A regulation is different. It applies directly to everyone, right away. No need for local laws to make it work. It makes the rules the same everywhere in the EU. We also have the e-Privacy Directive. This is about cookies and spam marketing. It works with the GDPR. The GDPR covers personal data, but e-privacy covers electronic communication. You also need to know the players. The European Court of Human Rights deals with the Convention. The Court of Justice of the European Union, CJEU, deals with EU laws like the GDPR. They are the top judges. If they say a rule is broken, everyone has to listen. Questions. 1. Who created the European Convention on Human Rights? Answer. The Council of Europe. Explanation. The Council of Europe focuses on human rights and created this convention. It is separate from the EU. 2. Does the OECD create binding laws for countries? Answer. No. Explanation. The OECD guidelines are recommendations or good advice, not binding laws. 3. What was the first legally binding international instrument for data protection? Answer. Convention 108. Explanation. Passed in 1981 by the Council of Europe, this was the first binding treaty. 4. What is the main difference between a directive and a regulation in EU law? Answer. A regulation applies directly, while a directive needs local laws to be passed first. Explanation. The GDPR is a regulation, so it applies immediately across all member states. 5. Which article of the European Convention on Human Rights protects private life? Answer. Article 8. Explanation. Article 8 guarantees the right to respect for private and family life. 6. Which court handles cases related to the GDPR interpretation? Answer. The Court of Justice of the European Union, CJEU. Explanation. The CJEU is the highest court for EU law matters. 7. What does the e-Privacy Directive mainly cover? Answer. Electronic communications, like cookies and marketing emails. Explanation. It is a specific law, lex specialis, that works alongside the general GDPR. 8. What is the Treaty of Lisbon? Answer. It is a treaty that gave the Charter of Fundamental Rights the same legal value as treaties. Explanation. This strengthened data protection as a fundamental right in the EU. 9. If the e-Privacy Directive and GDPR conflict, which one do you follow? Answer. The e-Privacy Directive. Explanation. The specific law, e-Privacy, usually overrides the general law, GDPR, on specific topics. 10. Is the United Kingdom part of the EU? Answer. No. Explanation. The UK left the EU, so it is now considered a third country under GDPR. 11. What is the Charter of Fundamental Rights? Answer. An EU document that lists human rights, including data protection. Explanation. Article 8 of the Charter specifically mentions the protection of personal data. 12. Do strict data privacy laws hurt or help international trade? Answer. They can help by building trust. Explanation. When countries trust that data is safe, they are more willing to share it. 13. What defines personal data? Answer. Any information relating to an identified or identifiable natural person. Explanation. If you can figure out who the person is from the data, it is personal data. 14. Does the GDPR apply to dead people? Answer. No. Explanation. The GDPR only protects living individuals. 15. What is special category data? Answer. Sensitive data like health, race, or religion. Explanation. This data needs extra protection because using it can hurt people more. 16. Does GDPR apply to a company in the US? Answer. Yes, if they sell goods to people in the EU or track their behavior. Explanation. This is called the extraterritorial scope of the GDPR. 17. What is the material scope of the GDPR? Answer. It applies to processing personal data by automated means. Explanation. It covers computer files and organized paper filing systems. 18. Does GDPR apply to me if I keep a personal address book for my friends? Answer. No. Personal, non-business use is not covered. 19. Who is a data subject? Answer. The living person the data is about. Explanation. In the context of GDPR, the human being is always the data subject. 20. What is processing? Answer: anything you do with data. Explanation: collecting, storing, deleting, or viewing data counts as processing. Now, let's look at the core of the GDPR. Imagine the GDPR is a house. Article 5 is the foundation. If you follow Article 5, you are mostly safe. If you break Article 5, the house falls down. There are 7 key principles here. First is lawfulness, fairness, and transparency. You must have a legal reason to take data. You must be fair, don't trick people. And you must be transparent, tell them what you are doing. Second is purpose limitation. This is very important. If you collect email addresses to send a receipt, you cannot use them later to sell advertisements. You must stick to the original reason. Third is data minimization. Don't be a hoarder. Only take what you need. If you sell shoes, you need a shoe size. You do not need to know the customer's religion. Fourth is accuracy. The data must be correct. If a customer moves houses, you need to update their address. Fifth is storage limitation. Do not keep data forever. If the customer leaves you, and the law doesn't say you must keep the records, delete them. Sixth is integrity and confidentiality. This means security. Don't leave the files on a train. Use passwords. Seventh is accountability. This is the boss principle. It means you are responsible. You must be able to prove you followed the rules. You also need a legal basis, Article 6. You cannot just process data because you want to. You need one of 6 reasons. 1. Consent, the person said yes. 2. Contract, you need data to deliver the pizza. 3. Legal obligation, the taxman says you must keep records. 4. Vital interests, to save a life. 5. Public task, government work. 6. Legitimate interest, it is good for business, and doesn't hurt the person. 1. If I collect data for shipping, can I sell it to a marketing firm? Answer: no. Explanation: this violates purpose limitation. You collected it for shipping, not marketing. 2. I want to collect all possible data just in case I need it later. Is this allowed? Answer: no. Explanation: this violates data minimization. You should only collect what is necessary right now. 3. A customer tells you their name changed. What must you do? Answer: update the record. Explanation: the accuracy principle says you must keep data up to date. 4. Can I keep employee records for 50 years after they quit? Answer: generally no, unless a specific law requires it. Explanation: storage limitation says you should delete data when it is no longer needed. 5. I encrypted the data, but I lost the key. Is this a breach? Answer: yes. Explanation: this is an availability breach. If you can't access the data, it's a problem. 6. What is the accountability principle? Answer: the controller is responsible for compliance and must be able to demonstrate it. Explanation: it is not enough to be good. You must prove you are good. 7. Is consent the only way to process data lawfully? Answer: no. Explanation: there are 6 legal bases, and consent is just one of them. 8. Can a child give consent for an online game? Answer: only if they are over a certain age, usually 16, but can be lower. Explanation: if they are younger, a parent must give consent. 9. Is a pre-ticked box valid consent? Answer: no. Explanation: consent must be an active, affirmative action. The user must tick the box themselves. 10. Can I withdraw my consent later? Answer: yes, at any time. Explanation: it must be as easy to withdraw consent as it was to give it. 11. I need to process data to pay my employees. What is the legal basis? Answer: performance of a contract. Explanation: you have an employment contract, and paying them is part of that deal. 12. A hospital treats an unconscious patient. What legal basis do they use to check his ID? Answer: vital interests. Explanation: this is used to protect someone's life when they cannot give consent. 13. What is legitimate interest? Answer: when processing is necessary for your business, and it doesn't override the user's rights. Explanation: you usually need to do a balancing test to prove this. 14. Can I process criminal record data freely? Answer: no, it has very strict rules. Explanation: only official authorities or specific laws usually allow this. 15. What makes consent informed? Answer: the person knows who you are and what you will do with the data. Explanation: if they don't understand what they are agreeing to, the consent is invalid. 16. If I process special category data, like health, what do I need? Answer: you need a legal basis, Article 6, and an exception, Article 9, like explicit consent. Explanation: regular legal basis is not enough for sensitive data. 17. Is a photo always biometric data? Answer: no. Explanation: it becomes biometric data only if used to uniquely identify someone, like facial recognition. 18. What implies that consent must be freely given? Answer: the person must have a real choice and not be forced. Explanation: if an employee feels forced to say yes to a boss, it is not freely given. 19. Transparency means providing information in what way? Answer: concise, transparent, intelligible, and easily accessible form. Explanation: no long, confusing legal language. Keep it simple. 20. If the law changes, do I need to change my processing? Answer: yes. Explanation: compliance is an ongoing process, not a one-time check. Section 3. Rights of the data subject. In this section, we talk about power. The GDPR gives power back to the people. These are called data subject rights. As a user, I have the right to know. This is the right to be informed. You must tell me who you are and what you are doing with my info. You usually do this in a privacy policy. Then, I have the right of access. You have to show me. You usually have 1 month to reply, and you cannot charge me money for the first copy. I also have the right to rectification. If you have my name spelled wrong, I can force you to fix it. A famous one is the right to erasure, also known as the right to be forgotten. If I want to leave your service, I can ask you to delete everything. But, be careful. This is not absolute. If the bank has to keep my data for tax laws, they can say no to my erasure request. There is the right to restriction. This is like a pause button. The right to portability is cool. It means I can take my data from Spotify and move it to Apple Music, if the formats work. It allows me to switch services easily. Finally, the right to object. Specifically to direct marketing. If I say stop marketing, you must stop immediately. No arguments. Questions. 1. How long do I have to respond to a subject access request, SAR? Answer. 1 month. Explanation. You can extend it by 2 months if it is very complex, but you must tell them why. 2. Can I charge a fee for a subject access request? Answer. No, not for the first copy. 3. A user asks to be forgotten, but the law says I must keep the record for 5 years. What do I do? Answer. You keep the data. Explanation. Legal obligation overrides the right to erasure. 4. What is the right to portability? Answer. Transferring data from one service provider to another in a machine-readable format. Explanation. It helps prevent lock-in with one company. 5. If a user objects to direct marketing, can I refuse? Answer. No. Explanation. The right to object to direct marketing is absolute. You must stop. 6. Does the right of access include seeing internal notes about the customer? Answer. Generally, yes. Explanation. If the notes contain personal data, the user has a right to see them. 7. What information must be in a privacy notice? Answer. Identity of controller, purpose of processing, recipients of data, and rights of the user. Explanation. It must act as a clear guide for the user. 8. Can I make a request over the phone? Answer. Yes. Explanation. A request does not have to be in writing to be valid. 9. What is automated individual decision-making? Answer. Decisions made by a computer without a human involved, like a loan refusal by an AI. Explanation. Users have the right not to be subject to this if it has legal effects. 10. When can I use the right to restriction? Answer. When you can test the accuracy of the data. Explanation. The processing pauses while the accuracy is verified. 11. Do I have to delete data from backup tapes instantly upon an erasure request? Answer. It can be difficult, but you must ensure it is overwritten eventually or put beyond use. Explanation. You must explain your backup cycle to the user. 12. Does the right to portability apply to paper files? Answer. No. Explanation. It only applies to automated, digital, data. 13. If I deny a request, what must I tell the user? Answer. The reason why, and that they can complain to the supervisory authority. Explanation. You must always give them a path to complain. 14. Can a parent make a request for their child? Answer. Yes, if the child is young. Explanation. The parent acts on behalf of the child's rights. 15. What implies a request is manifestly unfounded? Answer. If the user is just trying to harass the company with no real intention. Explanation: this is a high bar to prove, so be careful using it. 16. Who verifies the identity of the person making the request? Answer: the controller. Explanation: you must make sure you are sending the data to the right person, not a hacker. 17. Does the right to object apply to legitimate interest processing? Answer: yes. Explanation: the controller must then prove their interest is more important than the user's rights. 18. Can I respond to a request via email? Answer: yes, and it is usually preferred if the request came via email. Explanation: it should be secure. 19. What is profiling? Answer: using data to evaluate personal aspects, like predicting work performance or health. Explanation: users must be informed if profiling is happening. 20. Is the right to erasure the same as the right to rectification? Answer: no. Explanation: erasure deletes data, rectification corrects wrong data. Section 4. Controllers and processes. This section is about roles. Who is who? The controller is the boss. They decide why and how data is used. If you are a shop and you decide to collect customer emails, you are the controller. You are responsible for everything. The processor is the helper. They process data on behalf of the controller. Think of a cloud storage company or a payroll company. They don't own the data. They just hold it or work on it because the controller paid him to. However, a processor still has rules. They must secure the data. They cannot use the data for their own business. If the payroll company takes your employee list and sells it, they are breaking the law. You need a contract between the controller and processor. This is called a data processing agreement, DPA. It sets the rules. Sometimes, you need a data protection officer, DPO. You need one if you are a public authority, like the government, or if your main job is tracking people on a large scale, or processing sensitive data on a large scale. The DPO is an expert. They must be independent. You cannot fire the DPO just because they give you advice you don't like. We also have privacy by design. This means when you build a new app, you think about privacy first, not last. Privacy by default means the settings should be high privacy automatically. The user shouldn't have to search the settings to be safe. If something goes wrong and data is stolen, that is a data breach. You must tell the supervisor, the government, within 72 hours. If the risk is high to the people, you must tell the people too. Questions. 1. Who determines the purposes and means of processing? Answer: the controller. Explanation: this is the definition of a controller. They are the decision makers. 2. Can a processor hire another processor? Answer: yes, with written permission from the controller. Explanation: this is called a sub-processor. 3. If a processor causes a data breach, who is liable? Answer: both can be liable, but the controller is primarily responsible to the user. Explanation: the processor is liable if they didn't follow the contract or the law. 4. When must I report a breach to the supervisory authority? Answer: within 72 hours of becoming aware of it. Explanation: speed is important to stop the damage. 5. Do I always need a DPO, data protection officer? Answer: no. Explanation: only in specific cases, like public authorities or large-scale monitoring. 6. Can the DPO be the CEO of the company? Answer: no. Explanation: there is a conflict of interest. The DPO must be independent. 7. What is a record of processing activities, ROPA? Answer: a document tracking all data processing, required for organizations with 250 plus employees, usually. Explanation: it is like a map of all your data flows. 8. What is a DPIA, Data Protection Impact Assessment? Answer: a risk assessment you do before starting a high-risk project. Explanation: it helps you find problems before they happen. 9. What is privacy by default? Answer: the strictest privacy settings apply automatically without user action. Explanation: the user shouldn't have to change settings to be private. 10. Who is responsible for paying the fee to the processor? Answer: the controller. Explanation: this is a commercial arrangement, but not a GDPR rule itself. 11. Can a processor use data to improve their own AI models? Answer: only if the controller agrees and the contract says so. Explanation: otherwise, the processor becomes a controller for that new purpose. 12. What happens if I miss the 72-hour breach deadline? Answer: you must provide a valid reason for the delay. Explanation: if you don't explain, you can be fined. 13. Do I have to tell the users about every breach? Answer: no, only if there is a high risk to their rights and freedoms. Explanation: if the data was encrypted and safe, you might not need to tell them. 14. What is a joint controller? Answer: when two parties decide the why and how together. Explanation: they share the responsibility. 15. Can the DPO be an external consultant? Answer: yes. Explanation: they do not have to be a full-time employee. 16. What must be in the contract between controller and processor? Answer: the subject matter, duration, nature, and purpose of processing.